Hello everyone, my name is Mark Halsey. I'm here with Fiona Halsey and we are Halsey Legal Services. This is another in a series of webinars that we're producing in relation to financial services issues and compliance related issues. And today we're going to be talking about the latest round of AFCA proposals that have been published and open for public consultation. When AFCA, the Australian Financial Complaints Authority, was founded in 2018, the legislation establishing it provided that there would be an independent review of AFCA within 3 years. And an independent review was conducted by independent experts. A report was produced and presented to Parliament. That was on or about November 2021. So the move from that report to the AFCA proposal, which was published in March 2023, has taken a considerable period of time. The idea behind the AFCA proposals is that they are guided in a way by the independent review, and there are 14 proposals that are being put forward by AFCA. One of those proposals relates to the way AFCA deals with non-retail clients. It's proposal number 5. So Fiona, would you like to give us some idea of what the proposal is and what it means?
Well, yes. But before I do that, I think I might talk a little bit about what these different, these classifications of clients are that are relevant, because the proposal is around whether or not AFCA will be accepting complaints from particular categories of people who are, in broad terms, referred to as wholesale clients, sophisticated investors and professional investors.
Yep.
And that's the debate, is to whether those people should be able to access AFCA or not. And so you start with your wholesale clients, and they're the people that have got an accountant certificate where they've had gross income in each of the last 2 years of at least $250,000, or they've got net assets of 2.5 million. So that's your wholesale clients. Then you've got your sophisticated investors. And they are people who've got a certificate from an AFSL, which says that they have got sufficient experience, broadly speaking, in these kind of in the relevant kind of products, which means that effectively they can look after themselves. And then finally, you have your professional investors, and they are people who've got, they either control at least $10 million, they have their own AFSL, or they're carrying on financial services in such a scale that they're thought of as professional investors. So for example, a public super fund will be within that category. So you have those groups of people. Okay. And the general idea was always that those people would not be able to access AFCA. Okay. And you can see that by the way the licensing regime works. So if you're seeking to get an AFSL, you can either you apply for an AFSL, and you can be either you can deal with just wholesale clients, or you can deal with a mix of wholesale and retail clients. If you deal with wholesale clients only, you don't have to be a member of AFCA. But if you deal with a mix, you do have to be a member of AFCA. And the problem comes in that if you're a wholesale client of AFCA, if you're a wholesale client of a member of AFCA, then you can go in regardless of how much money you've got. But if you're a client of a wholesale only AFSL, you can't. And that was how it was intended.
Yeah, there is a discretion on AFCA's part to exclude non-retail clients if a complaint is lodged. What's been your experience?
My experience is they never exercise that discretion. So, I mean, I had one absolutely extreme case. He had $670 million, and they would not exercise their discretion.
So the client controlled $670 million and still was accepted.
And he didn't just control that money in the sense of like being a public, working for someone else who did. It was his own money.
Right.
Okay.
Right.
And so I found that, I thought that was probably the high watermark of an example of how it wasn't going to be exercised. So yeah, that's certainly my. But then the proposal that's been made is it's incredibly minimal, and I think people's idea was that as part of this review there would be, a greater restriction on these people being able to access AFCA. But in fact, it's not that at all. It's turned out to be, of the 3 categories of people we're talking about. We're talking about our wholesales, who are the accountant certificates, our sophisticateds, who are the ones with the experience, and our professionals, who are the ones control more than 10 million or in business.
Mhm.
And the idea is only, there's nothing to deal with the wholesale ones.
Mhm.
And with the other two, they've just decided they're going to apparently write down how they're going to exercise their discretion. So it hasn't been much of a move at all, as far as I can see.
Yeah, my reading of the proposal put forward by AFCA is that they don't even intend to change their rules. So effectively, nothing's changed.
No, exactly.
Yeah,
That's right.
which is extraordinary, particularly when you consider that the independent report's recommendation appears to have been that these people should not be able to access the AFCA jurisdiction.
Yeah, that's right. Exactly.
And the other thing that I found interesting is that the Treasury's response to the independent expert, I think Treasury has misunderstood the terms, to be quite honest, in reading the Treasury report, because they also stated that they felt that people who had an accountant certificate and the minimum level of wealth and income, $250,000 over 2 financial years, or $2.5 million, should also not be able to access.
Yes, they did, didn't they? I thought that was, but you know, they are such complex sections of the Courts Act.
Yep.
So, you know, when you're trying to work out who is a wholesale client and how that fits within that whole section 761G and GA, it's really difficult. And you can see how that's effectively worked. But yeah, so we've made a submission that we think that those categories of clients should not be able to access AFCA, because it seems, I mean, it seems wrong that if you are the client of a wholesale only license, you can't, but if you're the client of a mixed license, you can. It's the same person. Doesn't seem to make any sense to me. So we've made a submission, and we're happy to provide a copy of that to anybody who would like a copy. If you email us, we will send you a copy, and we've put our email addresses up on the slides at the end of this, and those comments have to be in by the 22nd of May.
Which doesn't leave a lot of time, but it still does leave some time to make that contribution. I think it's really important that existing AFS licensees, particularly those who are AFCA members, do get involved in this consultation process, because it affects them directly, and it is something that, by definition, where these wholesale clients can be subject to the AFCA jurisdiction and AFCA awards, which, unlike the court, are not subject to the right of appeal, and they also, as part of the AFCA process, dispense with some of the fundamental rules, such as the rules of evidence, strict rules of evidence, etc. Obviously, an important thing if you're dealing with small mums and dads, but a different matter altogether if you're dealing with people who are rich enough to be wholesale clients.
Yes. One of the things that I often find that when I'm dealing, because the vast bulk of AFSLs who are members of AFCA are actually they're mum and dad businesses is the wrong word, but I really do
small businesses.
They are. They're really small businesses, and when I quite often look at the wholesale client and I think, you've actually got greater assets than this person does. The client is actually bigger than, and we're starting to see them being represented by quite large law firms in AFCA. And it does seem like certainly an unfair situation,
sure.
Especially when all the costs of an AFCA complaint, all the charged costs of an AFCA complaint are paid by the AFSL.
Win, lose or draw.
Well, that's right.
It's paid by
exactly. And there's nothing to stop a person making a complaint. Really, it's completely in their court. And if AFCA makes a determination, and the situation is that the AFSL has got no choice as to whether they'll accept that determination or not. Right. It's binding on them.
No merits review.
Yeah, no, there's no review. There's no judicial review. Okay, and yet the complainant can choose whether they'll accept that or not. And if they don't, they can go off to court.
Yep.
So it's a fundamentally, it just seems to me an unfair situation, and it seems as though the intention was always that AFCA should be restricted to retail clients.
Absolutely, and the issue arises. I mean, it's evident from the Corporations Act. It's the point you made, which is that if a license issues without retail client authorisations, they're not even required to become members of an external dispute resolution body
No.
such as AFCA. So there was a clear intention on the part of the government that this was targeted at retail clients. The problem arises that when the rules of the first, and I can't remember whether it goes back to, it certainly goes back to the Financial Industry Complaint Service, the FIX. The people who drafted the rules drafted in such a way that it was actually inconsistent with the approach taken by the legislators, by Parliament. They actually broadened it to cover all clients of licensees with a discretion to exclude wholesale clients, the discretion to exclude non-retail clients. But I don't believe that that was really the position in law in the way in which the legislation set up the various components of the industry. Okay, so an important one for people to be aware of, an important one for licensees and particularly AFCA members to contribute to, because this is your opportunity to participate in that public consultation.
Indeed, indeed. So, if you would like a submission, or example of submission that you might put, please email us at one of the email addresses. But they are due by the 22nd of May. Thank you.
Thank you.
Bye.